Welcome back to online classes. Dear students, how are you? I am James here. Today is a very important topic. Okay, I am going to discuss with subject Indian Evidence Act. Okay. Today, section 112 of Indian Evidence Act. What is that? Presumption of legitimacy. Presumption of legitimacy. What is that? The main scope of the section is maternity is a fact and paternity is an imagine. Okay? Maternity is a fact and paternity is an imagine. I think this is very good topic. Okay, the word is also rhythmic word, and many peoples are affected in this area only. If the evidence is proved as per the right days, the Evidence Act allotted the particular days of a period, that particular days is fulfilled, the child is a legitimate child. Okay, otherwise the child is illicit child. So I already gave the important ingredients. Okay, now let's see of this portion. Maternity is a fact and paternity is an imagine. Maternity admits of positive proof, but paternity is a matter of inference. In India, the law of succession depends upon the paternity. Even the surnames are also derived from the side of father only. There are only a few areas having maternal heritage. Besides solving the succession disputes, legitimacy also stands as a factor in the disputes between the wife and husband, especially in divorce cases. Therefore, it was necessitated to the framers of the Indian Evidence Act to frame special provision for the determination of legitimacy. In those days, science and technology were not so developed. Hence, the framers adopted only the traditional means to prove the legitimacy. So, section 112 lays down the rule for the proof of the paternity of an individual. Okay. What act saying? Section 112, birth during marriage, conclusive proof of legitimacy. This is what act explained. Birth during marriage. Okay, birth during marriage, conclusive proof of legitimacy. That means the fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after this dissolution, that means divorce, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. Okay, the following points will be considered as ingredients of the section. Section 112 contains two presumptions. The first one is rebuttable presumption in favor of the legitimacy of a child born during the wedlock. According to this presumption, it is presumed that the husband had intercourse with the wife at the time the child must have been conceived. So this is a rebuttable presumption, and person opposing it is allowed to adduce evidence to show that there was no access between the husband and wife and that no sexual intercourse took place between them. The second is irrebuttable presumption in favor of the legitimacy. Basing upon this intercourse, sexual intercourse between the wife and husband, the law will not allow any inquiry whether the husband or some other man was more likely to be the father of the child. Thus, the presumption drawn after proving the sexual intercourse between the wife and husband, the presumption becomes irrebuttable and conclusive. Okay, and also section 112 provides conclusive presumption in favor of the legitimacy that a child born during the continuance of a valid marriage is a legitimate issue of those parents, no matter how soon the birth takes place after the marriage. And section 112 applies to the disputes pertaining to the paternity. The section does not apply to the disputes of maternity, because the maternity is a fact and paternity is an imagination. And also this section refers to the point of time of the birth of a child and not to the time of its conception as the deciding fact in a case of disputed legitimacy. So, as per this section, the valid marriage is an essential ingredient to presume the legitimacy of the child. And also within 280 days after dissolution of a valid marriage, here the phrase in the second part of this section implies that a child born within 280 days from the date of dissolution of a valid marriage will be presumed legitimate. The clause also applies in the case of death of the husband. Okay, a child born within 280 days from the date of death of his father is presumed legitimate son. The period of gestation period within the meaning of this section is 280 days. However, if the doctors certify explaining the reasons for the long period of gestation, that is 305 days, okay, or 308 days or 330 days, etc., may be accepted. And also access to each other, the first part of this section rebuttable by the husband or other interested party and is allowed to prove that the parties had no access to each other and that there was no possibility of access. The word access used in this section meaning actual sexual intercourses. Access means actual sexual intercourse. Okay, and another part of the same section I just wanted to give adultery means if the wife is having illicit connection with another person during the continuance of a valid marriage and the child born during the continuance of valid marriage, it is presumed that the child was born to the husband. And another point of view, disease, if sometimes disease will occur the father, except koja is one type of disease, eunuch, okay, the husband was suffering from any serious disease such as cancer, tuberculosis, even AIDS, etc., does not affect the presumption arrived under this section. Okay, students, and also I will give you death of the father means here based on this section, a child born after the death of his father is presumed to be the son or daughter of the late father. However, the gestation period and delivery date must not be improbable one, because one leading case taken from the All India Report Journal, a child born 9 months after the death of his father was held to be is legitimate. Okay. And Johnston J. M.T. Rakim B.B. is a appellant in this case versus Chirag Din and other respondents. This case also taken from the All India report dated on 1930, okay, in Lahore court. The case is a son was born to a Muhammad wife after 419 days, 419 days after husband's death. Okay, 419 days after her husband's death. And the court held that the period of gestation as so extraordinary, unusual, would prove the contrary to the mother's chastity, and thus the child born after 419 days was not accepted as the legitimate son of the deceased husband. Okay, not accepted. So this is the formulation of the under the section of Indian Evidence Act, section 112. Okay students, I will give you a case law. I will give you example and then case law also, because this here very important topic in this Evidence Act. Here one example: A was induced to marry B. Okay, A was induced to marry B, who was already pregnant at the time of marriage. Soon after the marriage, A drove out B on the ground of her concealed pregnancy. B takes the presumption under section 111. Decide. This is question of example. What is that? No. The presumption under section 112 cannot be extended to B, as the marriage itself induced one and there is no continuance of valid marriage. Okay. And another example of case: Ram Kishan Singh versus Savitri Devi. Ram Kishan, R-A-M, Ram Kishan, K-I-S-H-A-N, Kishan, Singh, S-I-N-G-H, Singh. Ram Kishan Singh versus Savitri Devi. Here the brief of the fact of this case: there was a quarrel between the wife and husband. There was a desertion, D-E-S-E-R-T-I-Y, desertion, for a period of 2 years. Okay. In this situation, the wife gave birth to a child during that period. The husband pleaded no access. You know very well the meaning of the access. Okay. He went to her parents' house only one time during 2 years. That too for talks, and was beaten by his brother-in-law. What is this judgment? Here the court clearly given held that there was no presumption of legitimacy. Okay, there is no presumption of legitimacy, because in this case the principles is applied as per the section 112 of Indian Evidence Act. Access in section 112 means effective access and sexual intercourse. The word of access and non-access are words of significance in matrimonial classes. The courts are bound to adopt the timorous course of construing such words of art means A-R-T, art in its correct and not in some vague and extended meaning. Generally, wife and husband live under one roof, whether it may be a hut or bungalow or a single room. It should be presumed that the pregnancy was due to the cohabitation with the husband. Okay. Here, based on this case, blood test or DNA test. After the time of drafting the Indian Evidence Act, Science and technology were in primary stage. Thus, the makers of Evidence Act adopted the most traditional test, that is 280 days test. Okay, that too the burden of proof lies on the person, most probably on the husband side, and in certain occasions heirs of the husband, to prove that the husband did not assist the wife for the 280 days, that is gestation period. Intercourse itself is a secret affair, it cannot be revealed. If the wife has adopted adulterous living or eloped with a paramour and conceived a child, the problem arises. It is a social problem for the husband. It is also a social problem for the child. Okay. So here the neighbors, relatives, friends, etc. know the characters of the wife and husband very well. They also know that the wife had illicit contacts with her paramour. It is well known proverb that the husband is the last person to know his wife's illicit contact. Okay. Nobody wishes to tell a husband that his wife is doing such a thing. When she elopes with her paramour, all show mercy and condolence on husband, some humiliate him. When her paramour has driven away her after enjoying her and her money, she may come back with a child to her husband's house. Then too the wife has right to claim her child as the legitimate child of her husband. The law says so. In that connection, law helps the wife. Okay. Not the husband. The husband cannot prove his non-access. Therefore, the child begotten by her paramour comes into the account of the husband. If there is possibility of deducting the percentage of child by the blood test or DNA test, it is well developed. There are several instances occurs in the hospitals in India. The female children are hated by some of mothers. A few such mothers have tried to substitute the male children with the cooperation of the hospital staff. Okay. On DNA test of the children and parents concerned, the children were handed over to their original parents. Several news items were published in the newspapers recently also. Okay. In olden period also it is very difficult. Nobody tolerated. Okay. In Naina Sagni, one case, Naina Sagni was burnt in tandoori stove. The remnants of Naina Sagni and her parents' blood samples were tested by the forensic department, Hyderabad, and certified that the dead body was of Naina Sagni. There are several worldwide instances of allegations about the illegal contacts, illegitimate children, okay, rapes, etc. In one of the leading case, Imran Khan, Michael Johnson, Muhammad Ali, etc. were prosecuted on such allegations. Their blood samples were taken to testify. However, in India, it is a regret to say that courts do not accept the blood test or DNA test for determining the legitimacy or parentage of the children in disputes. In the Western country, the courts order for the blood test or DNA test which are accepted to trace out the original father of the children in cases of the disputes. In India still now, the courts adopts the 280 days test and do not tend to accept the blood test, but rare case the DNA test for determining the legitimacy also. As stated by Supreme Court or as follows. Number one, the status and psychology of the child. Whatever the result may be, the status and psychology of the child is adversely affected. Such a child may in future become adamant and antisocial. And second point, personal liberty. The blood test is a constraint on personal liberty of a person. Number 3, assess and non-assess. The blood test may prove accurately the parentage. However, by blood test, the non-assess between the parties cannot be proved. Section itself is based assess of the parties. Therefore, the court cannot base a conclusion on evidence different from that required by the law, or decide on a balance of probability which will be the result of blood test evidence if accepted. And last point of the Supreme Court guidelines, consent of the parties. A leading case in Sajira versus PK Salim case, the Supreme Court held that for the determination of the paternity of child, the blood test can be conducted only with the consent of person, and the court cannot compel any person to undergo blood test. Okay, so this is what I explain about section 112 of the Evidence Act. Now it's clear, student? Okay, let's move on next section. Okay, I'm closing this session. We'll discuss with another section with another online classes. Okay, thank you students, take care, bye.